Convention of the Cooperation Council for the Arab States of the Gulf on Combating Terrorism, signed in Kuwait on 4 May 2004, entry into force, in accordance with Article 46 of the Convention, Depository, General Secretariat of the Cooperation Council for the Arab States in the Gulf. The states members of the Cooperation Council for the Arab States of the Gulf. Considering the basic values and principles set out in the Council Statute and reaffirming the resolutions of the Supreme Council relating to the fight against terrorism. Pursuant to the tenets of religion and morality and to the norms governing the human cultural heritage of the international community and of the Arab and Islamic peoples, and to the values and traditions of Gulf society, which call for the rejection of violence and terrorism in all their forms and manifestations. Reaffirming their commitment to international treaties, in particular with the Charter of the League of Arab States and the Charter of the United Nations. Aware of the growing scale of the phenomenon of terrorism, the threat it poses to the international community and to civilian life and its repercussions in the region. Aware also of their shared responsibility for maintaining security and stability on the basis of the principle of collective security and the fact that the states members of the Council form an indissociable whole. Desiring to protect their communities, peoples, cultural and historical heritage and interests from the threat of terrorism. Reaffirming the right of peoples to struggle by various means against foreign occupation and against aggression. Reaffirming also their commitment to addressing and collectively combating terrorism and their desire to extend and strengthen their coordination and to ensure that their actions are comprehensive and are mutually complementary. Reaffirming further their respect for human rights. Concerned by terrorism, which constitutes a grave violation of human rights, threatens the stability of states, disrupts international relations and hinders social, economic, cultural and intellectual development. Convinced that terrorism cannot be justified under any circumstances, notwithstanding its motives or objectives, and should therefore be combated in all its forms and manifestations, irrespective of its origin, causes or objectives. Determined to eliminate all forms of terrorism, related activities and the means used to support it, and to ensure that terrorists and terrorist organizations do not have access to any source of financing or assistance. Have agreed as follows. Chapter 1. Definitions and General Provisions. Article 1. For the purposes of the present convention, the following definitions shall apply. 1. Contracting state means any state member of the Cooperation Council for the Arab States of the Gulf that has ratified this convention and deposited its instrument of ratification with the Secretary-General of the Council. 2. Terrorist act means any act of violence or threat thereof, notwithstanding its motives or intentions, perpetrated to carry out an individual or collective criminal plan with the aim of terrorizing or harming people or imperiling their lives, freedom or security, or endangering the environment, any facility or any public or private property or occupying or seizing them, or attacking a national resource. 3. Terrorist offense means any offense or criminal attempt committed in order to realize a terrorist objective in any of the contracting states or against its assets or interests, or its nationals or their property, and punishable under the domestic law of that state, or incitement to commit a terrorist act or the promotion or defense of such acts, or the promotion, printing, publication or possession of any documents or recordings of whatsoever nature intended for distribution or shown to others with a view to promoting or defending such offenses. The supply or collection of funds of any kind with the aim of financing terrorist acts shall also be considered a terrorist offense. The offenses provided for in the following conventions are also considered terrorist offenses, with the exception of those excluded by the legislation of contracting states or states that have not ratified those conventions. A. Convention of the Organization of the Islamic Conference on Combating International Terrorism. B. Arab Convention on the Suppression of Terrorism. C. Tokyo Convention, Convention on Offenses and Certain Other Acts Committed on Board Aircraft, signed in 1963. D. Convention for the Suppression of Unlawful Seizure of Aircraft, signed at The Hague in 1970. E. Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation, concluded at Montreal in 1971, and the Protocol Supplementary to the Convention, signed in 1988, Protocol for the Suppression of Unlawful Acts of Violence at Airports Serving International Civil Aviation, supplementary to the aforementioned Convention, with Final Act, concluded at Montreal on the 24th of February 1988. F. Convention on the Prevention and Punishment of Crimes Against Internationally Protected Persons, including diplomatic agents, adopted by the General Assembly of the United Nations, at New York, on the 14th of December 1973. G. International Convention Against the Taking of Hostages, adopted by the General Assembly of the United Nations on the 17th of December 1979. H. Convention on the Physical Protection of Nuclear Material, adopted at Vienna on the 26th of October 1979 and opened for signature at Vienna and New York on the 3rd of March 1980. I. United Nations Convention on the Law of the Sea, adopted in 1983, and the provisions therein relating to piracy. J. Protocol for the Suppression of Unlawful Acts Against the Safety of Fixed Platforms Located on the Continental Shelf, signed at Rome in 1988. K. Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, signed at Rome in 1988. L. International Convention for the Suppression of Terrorist Bombings, signed at New York in 1997. M. Convention on the Marking of Plastic Explosives for the Purpose of Detection, signed at Montreal in 1991. N. International Convention for the Suppression of the Financing of Terrorism, adopted in 1999. 4. Activity to support and finance terrorism means any activity involving the collection, receipt, delivery, allocation, transportation or transfer of funds or of the proceeds of such funds with a view to facilitating the commission by an individual or group of a terrorist act within or outside the territory of a country, or banking or commercial transactions carried out in support of such acts or the perpetrators thereof, or the direct or indirect acquisition of funds with a view to drawing benefit from such acts, defending or promoting ideas, setting up training camps or supplying weapons or false documents, or providing any other type of assistance or funds in full knowledge of the purposes for which they are intended. 5. Funds means assets of every kind, whether tangible or intangible, movable or removable, and legal documents or instruments in any form, including electronic or digital, bank credits, checks of every kind, money orders, shares, securities, bonds, drafts and letters of credit. Article 2. A. Struggle by various means, including armed struggle, against foreign occupation and aggression and aimed at liberation and self-determination in accordance with the principles of international law shall not be considered an offense, with the exception of acts against the territorial integrity of any contracting state. B. None of the terrorist offenses provided for in the preceding articles shall be considered a political offense. For the purposes of this convention, the following offenses shall not be considered political offenses even when politically motivated. 1. Aggression against kings and heads of state of contracting states or against their spouses, ascendants or descendants. 2. Aggression against crown princes, vice-presidents, heads of government or ministers of any contracting state. 3. Aggression against persons afforded international protection, including ambassadors and diplomats of contracting states or those accredited to them. 4. Premeditated murder or robbery involving violence against individuals, authorities or means of transport and communications. 5. acts of sabotage and destruction of public or private property for public use, even if such property belongs to another contracting state. 6. The manufacture, smuggling or possession of arms, ammunition, explosives or other materials used to commit terrorist offenses. Chapter 2. Cooperation and coordination of security measures. Article 3. Contracting states shall endeavor to coordinate their plans and measures aimed at preventing, combating and suppressing terrorism. Article 4. Contracting states shall undertake to cooperate by lending the necessary support and assistance in the field of security to any contracting state that is threatened by or has suffered terrorist offenses or is suffering the consequences of terrorism, account being taken of the needs and circumstances of each state. Article 5. Contracting states shall endeavor to strengthen surveillance measures, assess security problems as well as terrorist threats and risks, conduct the requisite predictive analyses and studies and prospective research, and draw up security plans with a view to preventing and suppressing terrorism and thwarting terrorist designs. Article 6. Contracting states shall make every effort to prevent terrorist elements from entering or infiltrating their territory and to prevent their citizens from being induced to join illegal groups or to participate in terrorist activities, whatever their circumstances or motives. Article 7. Contracting states shall adopt such preventive, interdiction, measures as may be necessary to prevent the use of their territory as a base for the planning, organization or commission of terrorist offenses or acts, or for active or passive participation in such activities, and shall undertake to develop and strengthen systems for border surveillance, security and control with a view to preventing infiltration or circumvention of security measures. Article 8. Contracting states shall adopt such measures and make such arrangements as may be necessary to protect persons and public and private property and to strengthen systems for the protection and security of facilities, means of transport, diplomatic and consular missions, and the regional and international organizations and agencies that cooperate with them. Article 9. For the purposes of this convention, the contracting states shall undertake to 1. Exchange without delay information and data concerning terrorist threats and dangers and the probability of terrorist offenses. 2. Identify terrorist elements or persons suspected of having contacts or links with such elements. 3. Exchange without delay information and documents concerning any terrorist offense targeting any contracting state, irrespective of whether it is carried out within or beyond the borders of that state, as well as the results of investigations or inquiries carried out, and to establish the identity of those involved. 4. Proceed without delay with regular exchange of information on the methods and instrumentalities used to commit terrorist offenses and on the measures taken to detect, thwart or counter such activities, and to exchange expertise and experience relating to the technical and security measures taken to combat terrorism. 5. Organize, on a periodical basis and whenever necessary, personal talks, meetings and exchange visits between heads of counter-terrorism agencies. 7. Undertake research and studies and organize advanced training courses and traineeships for the various security services responsible for combating terrorism. 8. Take such measures as are necessary and sufficient to protect persons working in the field of counter-terrorism and their family members. Article 10. Contracting states shall undertake to make such arrangements and adopt such measures as are necessary to protect the confidentiality of any information, data or documents that they exchange relating to terrorism. Such information shall not be transmitted to any non-contracting state without the prior agreement of the state of origin. Article 11. Contracting states shall undertake to promptly adopt such measures as are necessary to identify, pursue and detain those responsible for terrorist offenses committed on their territory, to judge such persons in accordance with national legislation and to afford adequate protection to persons working in criminal justice institutions as well as full protection to those who come forward with information relating to terrorist offenses and to witnesses and experts. Article 12. Contracting states shall endeavor to coordinate their efforts and seek common positions on the problems and questions relating to terrorism that are included on the agendas of regional and international conferences and meetings. Article 13. Contracting states shall endeavor to raise awareness with regard to questions of security and law by conducting effective awareness campaigns aimed at strengthening active cooperation between individuals and agencies responsible for combating terrorism, and shall draw up protection measures to encourage the reporting of information that may help in the detection of terrorist offenses and the identification and tracing of the perpetrators. Chapter 3. Special cooperation to prevent the support and financing of terrorism. Article 14. Contracting states shall adopt such measures and make such arrangements as are necessary to monitor the financial activities of individuals and institutions and to detect activities for the support or financing of terrorism that are conducted on their territory, in accordance with their laws and regulations. Article 15. Contracting states shall do their utmost to prevent the entry, movement, transfer or exit of funds that are suspected of being used to finance or support terrorism, and to prevent their nationals and public and private institutions or individuals or such institutions located on their territory from engaging in such activities. Article 16. Contracting states shall undertake to exchange without delay any information or data relating to activities for the support or financing of terrorism and to preventive measures taken in that regard and to report such activities. Article 17. Contracting states shall exchange experience and information regarding the methods used in activities for the support and financing of terrorism and on the scientific and police methods for their detection, including the use of telecommunications, electronic systems and international information networks, the holding of personal talks and meetings and the establishment of a joint database. Article 18. Each contracting state shall take such measures, in accordance with its laws and regulations, as are necessary to identify, detect, freeze or seize funds and the proceeds thereof that are used or intended to be used for activities for the support or financing of terrorism, with a view to confiscating or exchanging such funds or proceeds or sharing them with other contracting states if the funds are linked to a terrorist activity that has targeted its territory or harmed its interests, provided such measure is necessary to detect the terrorist activity in question. Chapter 4. Cooperation and the mutual legal assistance. Article 19. Contracting states shall undertake to extradite persons accused or convicted of terrorist offenses in a contracting state and whose extradition is sought by that state in accordance with the provisions of this convention. Article 20. Extradition shall not be possible in the following cases: a. If the offense for which extradition is sought is deemed a political offense under the law of the state concerned; b. If the offense for which extradition is sought relates solely to a dereliction of military obligations; c. If the offense for which extradition is sought was committed on the territory of the requested contracting state, unless the offense has harmed the interests of the requesting state, and the law of that state provides that the perpetrators of such offenses shall be prosecuted and punished, and the requested state has not commenced the investigation or trial. d. If a final judgment having the force of res judicata has been pronounced by the competent authorities of the requested state or of a third contracting state. e. If the request is received after the expiry of the time limit for prosecution or if the penalty is no longer applicable after the expiry of the period provided for by the law of the requesting state. f. If the offense was committed outside the territory of the requesting contracting state by a national of another state and the law of the requested state provides that that type of offense, when committed outside its territory by a foreigner, may not be prosecuted. g. if an amnesty applicable to the perpetrators of such offenses has been granted by the requesting contracting state. H. If the law of the requested state prohibits it from extraditing its nationals. In this case, the requested state shall undertake to convict a national who has committed a terrorist offense in any other contracting state if the offense is punishable by deprivation of liberty of at least 1 year in both states. The nationality of the person whose extradition is sought shall be deemed to be the nationality as at the date of the commission of the offense for which extradition is sought, on the basis of investigations conducted by the requesting state. Article 21. If the person whose extradition is sought is the subject of an investigation, trial or conviction in connection with another offense in the requested state, his or her extradition shall be postponed until the investigation or trial is completed or the penalty has been enforced. The requested state may extradite a person provisionally in order to allow the investigation to be conducted or the judgment to be pronounced, provided that the person extradited is returned to the extraditing state before the enforcement of the judgment pronounced against him or her in the requesting state. Article 22. For the purposes of the extradition of the perpetrators of offenses in accordance with this convention, no account shall be taken of juridical differences that may exist between the domestic laws of the contracting states with regard to the classification of the act as a serious or ordinary offense or the classification of the penalty incurred, provided that the penalty, in both states, consists of deprivation of liberty for at least 1 year. Article 23. Contracting states shall undertake to provide such juridical and legal assistance as may be necessary for judicial investigations, inquiries or proceedings relating to terrorist offenses. Article 24. Contracting states shall undertake to provide the aid and assistance necessary to obtain evidence and for the purpose of investigations relating to terrorist offenses that have targeted one of them, at the request of the state concerned. Article 25. Contracting states shall undertake to act, to the extent possible, on any regulatory commission relating to criminal proceedings connected with a terrorist offense, in accordance with the convention adopted by the member states of the Cooperation Council for the Arab States of the Gulf on the enforcement of judgments, regulatory commissions and notifications. Article 26. Contracting states shall cooperate for the purpose of seizing the instrumentalities and proceeds of a terrorist offense or the objects used in the commission of or in connection with the offense and for the purpose of handing them over to the requesting state, whether such objects and proceeds are in the possession of the persons whose extradition is sought or of another person and whether or not such persons have been extradited, without prejudice to the rights of any contracting state or third party acting in good faith. Article 27. A state which is requested to hand over the instrumentalities or proceeds referred to in the previous article shall take all the measures and precautions necessary to effect the handover and may, for the purposes of domestic criminal proceedings, keep such instrumentalities or proceeds temporarily or ask the requesting state to which it handed them over to return them. Article 28. Contracting states may examine evidence connected with any terrorist offense committed on their territory against any other contracting state and take the measures necessary to preserve such evidence and to establish its legal validity. They may communicate the outcome to the state against whose interests the offense was committed if that state so requests, but may not communicate it to any third state without the prior consent of the 2 states concerned. Chapter 5. Competence. Article 29. Each contracting state shall adopt such legislative measures as may be necessary to establish its jurisdiction over the offenses referred to in this convention when a. The offense is committed on its territory. b. The offense is committed on board a vessel that is flying the flag of that state or an aircraft registered under its laws at the time that the offense is committed. c. The offense is committed by one of its nationals. Article 30. A contracting state may also establish its jurisdiction over any terrorist offense referred to in this convention when a. The offense is committed against one of its nationals. B. The offense is prepared and planned outside its territory with a view to commission on its territory. C. The offense is committed by a stateless person whose habitual residence is on its territory. D. The offense is committed against one of its state or public facilities abroad. Article 31. Each contracting state shall adopt such measures as may be necessary to establish its jurisdiction over the offences referred to in this convention when the alleged perpetrator is on its territory, or shall extradite him or her to another contracting state at the request of that state. Article 32. Whenever a contracting state that has jurisdiction over an offense referred to in this convention is notified or advised by any other means that one or more contracting states have instituted an investigation or a trial concerning such offenses, measures shall be taken by the competent authorities of the states concerned with a view to coordinating the action to be taken. Chapter 6. Implementation Mechanisms. Article 33. The exchange of requests for extradition and for police or legal assistance or judicial authority, the exchange of documents, objects and proceeds and the summoning of witnesses and experts shall be effected directly between the competent authorities of the contracting states, either through the Ministry of the Interior or the Ministry of Justice or their representatives, or through diplomatic channels. Requests and the documents which accompany them or relate to them shall conform to the legal procedures provided for by the laws and regulations of the requesting state and the requested state and by the treaties and conventions to which they are party. Article 34. Extradition requests shall be submitted in writing and supported by the following documentation: a. The original or a certified true copy of the judgment, warrant for arraignment or arrest, or any other court decision pronounced in accordance with the procedure provided for in the domestic law of the requesting state. A. The statement setting out the facts of the case and specifying the offense committed, the date and place of commission of the acts, the legal classification and a reference to an copy of the applicable laws, and a. Information that is as detailed as possible about the person to be extradited and any other information that may facilitate the identification of such person and the establishment of his or her nationality. Article 35. 1. The judicial authorities of the requesting state may ask the requested state, in writing, to place the person in question in pretrial detention, under pretrial arrest, pending receipt of the extradition request. 2. In such a case, the requested state may place the person in pretrial detention. If the extradition request was not supported by the documentation referred to in the previous article, the period of detention may not exceed 30 days from the date of arrest. Article 36. The requesting state shall attach to its request the documentation referred to in Article 34 of this convention. If the requested state recognizes the validity of the request, it shall instruct its competent authorities to act on the request in accordance with its domestic law and shall notify the requesting state without delay of the procedure followed. Article 37. 1. In the cases referred to in the two previous articles, the period of pretrial detention may not exceed 60 days from the date of arrest. 2. The person in question may be released on bail during the period referred to in the previous paragraph, provided that the requested state takes the measures it deems necessary to prevent the person from escaping. 3. Release of the person in question shall not prevent his or her re-arrest or extradition if the request is received later. Article 38. If the requested state considers that it needs additional information in order to be sure that the requirements set out in this chapter are fulfilled, it shall notify the requesting state and shall set, in conjunction with that state, a deadline for receipt of the desired information. Article 39. When a contracting state is seized of a number of extradition requests from various other contracting states concerning the same act or different acts, it is the responsibility of that state to take a decision on the requests, bearing in mind all the circumstances, such as the possibility of subsequent extradition, the date of receipt of requests, the gravity of the offences and the place where they were committed. Article 40. Subject to the laws or regulations in force, contracting states shall make witnesses and experts available to the competent authorities of the requesting state and shall not take any action against or impose any penalty or coercive measure on witnesses or experts who refuse to go to the requesting state. If the witness or expert voluntarily goes to the requesting state, he or she shall appear before the courts in accordance with the laws or regulations of the requesting state. The witness or expert, irrespective of his or her nationality, may not be prosecuted or deprived of his or her liberty for acts or judgments predating his or her arrival. The witness or expert shall forfeit the protection provided for in the previous paragraphs, while still having the option of leaving the requesting state, if he or she stays in that state for more than 30 days after the completion of his or her tasks, or if he or she returns to the territory of that state after leaving it. The requesting state shall undertake to take all such measures as may be necessary to provide legal and police protection for witnesses. Article 41. Each state shall pay its share of the costs associated with the implementation of this convention. The requesting state shall pay the costs associated with the handover of wanted persons or of objects and proceeds connected with the offense, and costs associated with the appearance of witnesses and experts. Article 42. The Secretariat General of the Cooperation Council for the Arab States of the Gulf shall establish, in agreement with the contracting states, the mechanisms, measures and operating arrangements necessary for the implementation of this convention.